run yet?
No, we moved,
Need to run.
we moved
Hey,
RV and stuff in
Yeah,
this
it's
morning.
been a while, yeah.
And got all
Been never,
our
I guess,
living
but yeah.
set up, and then we move all the equipment in tonight.
Okay.
We can go in at 9 o'clock tonight.
That won't be bad. That'd be cool by then.
You come
Yeah,
on Thursdays a lot, I think.
Is that what you said?
then we have
Yeah.
all day tomorrow
Yeah.
to bring cattle in.
Let me just go.
What's the conference in Nashville right now?
It's the National Conference of State Legislators. So,
Barns are pretty full for 4-H.
5,000
I mean,
legislators
it looked pretty
across the
good.
country and other producers. There's always a lot from Canada, South Africa.
So we do it all here.
So it's
Get on wireless
legislators
here, Byron, and just,
Yeah, just go
and then
to,
Wi-Fi.
So we always
yeah,
exhibit out there and then.
yeah, Indiana
the
Public
different sections about
Wi-Fi.
the financial services.
and it'll let you right in, and it's actually pretty good Wi-Fi.
That's right, because Representative Clear wants to start doing this too, so he was able to help with that.
I was gonna say, well, if the school law book that is published every year is any indication, it's like 1,500 pages and covers almost like every chapter or title. So it touches everything.
No, they actually, during this last session, they cut the number of
Tammy
pages
and Herm
to
just
20.
texted me to
Oh,
tell
press that to the right.
It's like the first time it's gone.
Yeah.
Hi, Tammy.
I'm going for never.
Like, be like, careful.
No, that's
It's
it.
still like a little over 1,400 pages.
What's the biggest title?
I don't know.
how'd you like me to have that? Time, Byron. Hit the wrong button.
Is she- Oh, she's not keeping us laugh.
Or listen. Yeah.
I forgot, I missed that, because I was thinking, Lisa, Lisa, remind me, I have a potential opportunity for your son. Can you remind me about that when we talk afterwards? Yeah. Yeah, thanks. Yeah. Should I show you that, Lisa? I was thinking about him over the weekend.
Is it team time?
Hmm?
Is it team time?
I told them they could watch it online if they wanted, but Kim said she and Anna talked to me. I'm Ray's gonna come over a bit. She has another meeting here too. Okay, yeah. This is not Jim.
Okay, it's showing 1 o'clock. Can we have a roll call, please?
Dr. Paulson,
Present?
Mr. Boehner,
Mr. Boehner couldn't be here today. I'm Lisa Paddock, and I'm representing InSource for Mr. Boehner. This is proxy.
Mr. Prashant. Here. Ms. Dodson,
Present?
Ms. Long,
Present.
Mr. Mapes,
Here.
Mr. Rhodes,
Present.
Ms. Tanzel, Dr. Taylor, Ms. Weatherall, Dr. Ernest.
Present. Thank you. If we could say the pledge to allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I would entertain a motion to approve our agenda unless there's anyone who has a change.
So moved? Second.
Okay, it's been moved and seconded to approve the agenda. All those in favor say aye.
Aye.
Any opposed? Okay, thank you. I would also entertain a motion to approve the minutes from the last meeting unless someone has any additions or corrections to those.
So moved.
Second.
Been properly moved and seconded to approve the minutes. All those in favor say aye.
Aye.
Opposed? Motion carries. Comments. The only comment that I would make, actually two things from last meeting, and I want to throw those out there just to, and actually some of us were discussing this before the meeting a little bit as well. I think for me, themes that came out of the last meeting that I heard were, how do we make sure that our hearing officers are trained properly? And that seems to be a theme, and more training, those kinds of things. And then also, how do we make sure that we have all the resources? I continue to always be amazed at all the resources that are out there. And then how do we get all of our schools and families connected to those resources and make sure we have the people to the right places, right, and the right information. So those would be my comments as we begin this meeting, and I would open it up if there are any members that have any comments to make as well as we get started. Anybody have anything that you'd like to share? Okay, seeing none. That was not the proper teacher wait time, but I'm not waiting. So let's move on to our public comments, and I believe we have one. Tim, is that still correct?
That is correct.
Okay.
Christy Cundiff?
Thank you for being here.
Hello. I'll pass these out if.
So I do have one.
Oh.
I'm sorry, I didn't get you one.
No, you're fine.
I know Lisa, but I think you're about the only one that I know. My name's Christy Cundiff, and I am CEO of the Indiana Foster and Adoptive Parents Resources and Advocacy Group. I represent about 10,000 people throughout the state of Indiana, and even though it says foster and adoptive parents, I also, we have a multitude of different disciplines in our group. We have superintendents, teachers, doctors, lawyers, judges, about 150 state representatives and senators from the over across the street there, sidewalk. And we work a lot in trying to better laws and to provide resources and advocacy and support to foster and adoptive families throughout the state of Indiana. My husband and I adopted 8 special needs children from the Department of Child Services. Every single one of them had IEPs in the state of Indiana. 2 of our children are seriously mentally ill. And my concern is when I read down through, and it was kind of brought as a red flag to me about trying to minimize maybe the dispute process or trying to come up with a resolution or a solution between parents and school corporations. That's why I really wanted to come here today and share with you kind of what I went through. And I know I'm on 3 minutes, so just yell at me when my 3 minutes are up, or I'll keep you too long. But we actually, one of the struggles foster parents have when they adopt children is all adoptive children typically come with adoptive Medicaid, which is the traditional Medicaid. So we are very limited in our resources here in the state of Indiana on treatment facilities for children. You've probably all heard that before. And we had a daughter that was diagnosed with schizophrenia at 10 years of age that we adopted, which she was in the 1% population worldwide for a child to be diagnosed with schizophrenia at 10. It's very unheard of. So what we ran into is every facility in the state of Indiana turned her down for treatment. Nobody could help her. Yet when you adopt a child and you have no funding source outside of the state of Indiana, what do? And she has command auditory and visual hallucinations. She was having lots of problems in the school. She actually stabbed a little girl in the back with a pencil 3 times. It looked like the little girl had been shot, just unprovoked. We can go on about that. My school corporation's solution was to start calling the police on her in the 4th grade. And I'm not sure what that was going to evolve, but as a parent, I said, no, we are going to get her the help that she needs. And so inevitably she was, we filed for due process against the school corporation. She went out to Colorado and was out there for 2 years. And we flew back and forth and saw her every other month, our family. And they had done all they could do for her there. So now she's back in Indiana. So that's a huge problem for the children who will be adopted in the future in our state and now, that adoptive parents cannot go get the resources that they need for children. And I'm experiencing this again because now her brother has also been diagnosed with serious mental illness. So 4 years after the fact, when we were trying to get him help, I called 31 different facilities in the state of Indiana, and one of them said that they could help him. And so that's where he's at right now. But Medicaid is the funding source. And so, again, we filed for due process against our school corporation to try to get him the help that he needs. I always say special education is the most underutilized resource that we have in the state of Indiana. I always gear my foster parents and adoptive parents toward working with their school corporations, but honestly, some of the stories that I hear is there is no accountability. That if we take away or we want to add a state board of appeals, I think of what would have happened in my daughter's situation while we were waiting on that appeal. Would she have still been left in the school and dangerously hurting people? Would she be sitting in the juvenile detention facility, not getting the help that she needs? So I think that that is a very, very dangerous option to offer a state board of appeals while somebody is going through the due process here.
At the committee's discretion, if you'd like the person to continue, she may.
Finish your thoughts.
I just am really concerned that that's going to stop a lot of children. If from what I understand, I'm not sure, I know that the details aren't there yet, but if you put a state board of appeals into place, that's going to really just stop a lot of what can be done. And what are going to happen to those children? Where are they going to be? Are they going to be in the schools unsafe? Are they going to be at home unsafe? Are they going to, what's going to happen to them? And then you're also going to take away the timelines that parents have to follow to try to get beds for children. So the beds here in Indiana are few and far between. I've witnessed that here in the last 4 months. And we're just in the school corporations, at a mental health care crisis right now. And our children are not being served the way they need to be served.
Thank you. Thank you very much. Appreciate that.
Can I ask her a question?
Sure.
What was the due process for the district? What happened?
For my daughter, we filed it and they were against it at first, and then the day before the resolution meeting, she annihilated the classroom and threw chairs and tables and was very destructive. And so the school corporation said, okay, where do you want her to go? We're willing to do this because they saw how dangerous she was. With my son right now, they're fighting it, saying that he does not need a mental health care inpatient unit, even though he's there.
The difference was what the district was trying to keep him inside the district and provide services.
Right.
And you wanted a placement outside of it.
Well, and he's in a placement right now, and he's 3 different psychiatrists have provided documentation saying that he needs to be there. His therapist has provided documentation, but the school corporation is just not listening to that recommendation right now. So we're headed for due process in September.
Okay, thank you.
May I ask a question? I just want some clarification on your comments about the Board of Special Education Appeals, because the way we had it before, under the regulations, the board was supposed to make its decision within 30 days. So it was not a long timeline, although a party could ask for an extension of time, versus when parties appealed their hearing decision to court, those often take several years. So I didn't understand why your comments about made it sound like this would be a long time for a child to be languishing, and where would they be?
Right, but a lot can happen in 30 days. I mean, I can tell you that it's what I have seen personally with the 2 children that I've adopted, and you have many children in the state that has suffered insurmountable traumas. You have children, just in our situation, was born meth positive. They were fetal alcohol. One was a shaken baby. One was moved through the foster care system. The 3 of them were moved 7 times in 2 years. And so you're seeing more and more children experience trauma, and a lot can happen in that 30-day time frame of not keeping other children safe. my husband and I's position has always been that we were always concerned that, one, that the other children and the teachers and the staff were safe around our daughter, and two, that she was kept safe. And that's what we really need to focus on, is the safety and the well-being of the students in the school system. And you have a typically developing child coming to school witnessing the violence of an acting out child who's seriously mentally ill. That's really not a good thing for those kids to have to witness, or for the teachers to have to clear the classrooms out for one child, because it interrupts their education and their school day. Does that make sense? Does that answer? Okay.
Thank you very much. Okay, get into our discussion items then. The first discussion item A is just a recap of the Department of Education's cost of education disputes report. I know, Dana, you are still working on the questions from the last time, right?
Right, I actually had asked him whether we could, hold off to those questions for the particular,
Sure.
Meeting when we're going to address those topics, because some of these things are gonna take my team hours
Absolutely.
to do, because we have to go back and do it all manually, okay? We don't have a way to just pull that data out.
And that makes perfect sense as well, but we just wanted to update that and give a chance in that. Is there anything that anyone had after you, because I'm sure this is all you've thought about since the last meeting and really had a chance to reflect. Is there anything that anybody wants to ask that we didn't maybe get asked, or anything you want to discuss related to that report and that discussion from last time? I wanted to give that opportunity, particularly like Kim, I knew you had someone here, but whether you had anything or not, or anything anybody else had at all.
Nothing huge, I don't think. But I was curious on, and we don't need it for today, obviously, but just the number of kids receiving special education services in Indiana, just kind of the total number, out of curiosity, as well as the number of school districts in Indiana. I think both those would be helpful just to
Just
kind
a
of.
ballpark figure, I think we're around 170,000.
Okay.
160 to 170,000 kids, but I can get you more specific information.
Okay. And then the number of school districts in Indiana, just out of
Close
curiosity.
to 400. Again, we'll give you those specific
Sure.
numbers. I don't have
Count
those.
public charter lodges.
Really?
Probably public districts is probably,
Do you want charter schools in with that too? They are public
Yeah,
schools.
92.
then yeah, probably, yeah.
It's 292, isn't it?
292.
Yeah. Not with the
You're
charter.
thinking schools.
Not with charter school?
Not with
Oh,
charter.
okay, yeah, I'm thinking total with
Yeah.
charters.
Okay. That'd be helpful, thank you.
Okay.
I'd be curious of what the questions are, Dana, that you're working on getting answers to. We had a lot of great discussion, and so if you guys are busy researching something, if we could have clarity on just what those questions are.
Dana, help me out. I think I have these. Help me if I need to add to this, but I think I can help with this. Copies of the surveys used by the IDOE in preparing the report.
That I did send to you.
Yes, yeah, okay, yeah. Yeah, I should have checked that. Possibility of now this was more of just a question to them. Possibility of the IDOE following up on the surveys of hearing participants. Settled case reviews and oversight. Am I on the right list here?
There were some specific questions to the report that I forwarded to Dana from the last meeting. Those were more open topics for discussion.
Then let's get the specific ones then. Do we have those?
Part of what we're looking at right now is those cases that were appealed to the BSEA and the outcome of that. And then going back to some others, just generally how many hearing requests were filed in a year, how many actually went to hearing, how many of those were appealed, whether it's the BSEA or after the elimination of the BSEA, how many were appealed onto court. And getting the resolution of those is much more difficult for us because nobody has to tell us what happened in court.
Right. Did that answer your question?
Yes, thank you.
Perfect. Anybody else, anything there at all?
I can tell the group that if anybody's interested in going back and looking at the initial discussion on those questions, the discussions occurred on a video at about the 2-hour mark, the 2 hour and 17 mark.
Nice, Tim. Very good.
And if anyone is interested in looking at old hearing officer decisions, they're almost all posted on our website. We have found, going through this process, that apparently there were a few that got missed and weren't posted, but, so Kim's working on that.
Okay. Cool. Thank you. Anybody else? Anything at all there? Okay. Moving on to part B. Today, our discussion was going to be around category 6. Patterns of complaints that emerge regarding special education rights and services in order for the department to develop strategies to better resolve issues that lead to a particular pattern of complaints. And I would just open that up to discussion at this point from the group. And and if there's none at that point ready to, we can move to our policy discussion here. We've got Dr. Balsey ready to present some things. We can go to that and then come back to that, whatever the pleasure of the group is on that.
I think in patterns of complaints, it'd just be good to be knowledgeable about the common issues that arise so that as our group works on solutions, that we can just keep those at the forefront. Like, are we seeing lots of issues around needs for children with mental health supports? Is it around discipline a lot? I think that to me is the value in knowing those patterns of complaints so we can use them to help create solutions.
Mm-hmm.
I think that was the goal of the legislation, was to see if DOE has a way of looking at the complaints to see what issues are doing it.
That information was provided
Yep.
in the report on the complaints. That was on pages 12 and 13 of the report. It lists by citation those four. But again, this was just for fiscal year 2019 because that's all we can pull out of our database at this time.
And those are patterns of state complaints, correct?
Those are state complaints.
Okay, so those aren't necessarily patterns that emerge out of requests for due process hearings.
I didn't take the legislation here as calling due process hearings, calling hearings complaints. So I was looking at that as a complaint issue versus a hearing. I know federal law refers to it as due process complaints and state complaints, but generally at the state level, I thought they were talking about state complaints.
Sure. And Tim, I'd sent you an email just to, the legislation, the way it's written, it identified 745-1, which is actually the state complaint process. And I wondered if it should have been just Rule 45 in general, which is all of the areas. I don't know. Our committee just may want to think about state complaints are very different than topics that come to mediation or topics in which a request for a due process hearing is filed. And when we think about things that folks get most passionate about, the families need to go to that, feel they need to go to that route, or issues that are causing a lot of heartburn for everybody, I think they are definitely in the complaint areas, but also in the request for due process areas as well. So I think it could be interesting whether we have it now or it's something we agree to collect into the future. And so that's what you've got there.
That was also provided in the report.
Got
Issues that arose in mediation as well as hearings on pages 10 and 11 of the report.
Perfect. Yeah. And
I received a message. Dana, can you move your mic closer to people who are having a hard time hearing you?
That's intentional.
But like Kim said, I think the intent was so that we just continue to be aware of the issues. So as we work towards solutions for everybody, that we keep in mind what's the most pressing needs out there for families and kids.
So Dana, would you have any, given that comment, which I think is why that's on the agenda, what do you see anything that we right now need to keep at the forefront of our thoughts from that data that you saw?
Well, I think one of the things that, a month or so before our first meeting, I met with the State Advisory Council, and some suggestions they had were to provide some joint trainings with schools and parents over some of the most common issues, and to make sure that both parents and schools are aware of like facilitated IEP processes. So, and to help parties communicate better, because a lot of this seems to be a lack of good communication between the parents and schools. So we're certainly open to that. If you look at these and see certain patterns, that maybe there are particular topics that we could work together with iCase or something and InSource even, and, do some trainings around the state that include parents and parent representatives as well as school people. We're certainly open to that.
Let me ask a question on your report. So as I'm looking at this, and I will be the first one, I'm running on a little bit of a lack of sleep, but I want to make sure I'm reading this right. So even like that first box then, so for 2017 mediation issues, there's a total of 59. So this then breaks down what those 59 issues were?
Well, there might be more than 59
I guess I'm trying to
issues
understand the
listed
zero
there.
then. So then
Well,
why would some things be listed with a zero?
because we have check boxes in our iChamp system for both hearing officers and mediators, for the hearing officer or mediator to check the box whether this was an issue in this mediation or if this was an issue. So it's going to show up there.
So this is the exhaustive list of why it would have been requested, so it shows how many.
Yeah,
Okay.
these are the major issues, types of issues, and it's kind of global. It doesn't give you a lot of specifics, okay? And we wouldn't know that in mediation anyway, because mediation is all of it's kind of confidential, but mediation, even the discussions are confidential. We have no way of knowing what happened there.
I think, I think it'd be helpful to an extent to somewhat grasp this information and obtain it. I don't know how it's best done. I think we talked about last meeting how the mediation and the due process lists were different, and they're, like you mentioned, global. So maybe, I don't know, I think you said that those came from the kind of the paper versions that they were previously used and kind of put into the computer system. I think it'd be helpful if there's going to be changes there to try to grasp this information, to have those be maybe a little more detailed and the same, so we can kind of compare apples to apples. I still think it may be difficult to find a pattern statewide, since it's specific districts. They're all unique. They're all, kind of their own little worlds. And it's not a statewide issue. It's kind of maybe an issue that may be popping up at a certain district. So that may be difficult to try to kind of grasp. Also, I think it might be difficult to try to fix as well, given the same reason that these are kind of the same districts. We occasionally might find, say, as an example, an evaluation issue at a certain district that they're kind of unwilling to evaluate. Bring a couple cases out of that district, but it's certainly not an issue at some of the other districts. So kind of finding a global pattern just might be difficult, just from the construct of how the system is created. I think it might be helpful, but from a global standpoint, I think, as the data kind of shows, is probably evaluation, appropriate services, placement, discipline. Those are probably pretty much it, with maybe some outliers here. I think it would be nice to know if, say, mental health services specifically is one of those areas that keeps popping up, but I don't think any way is grasping that or obtaining that out of the complaints or due process filings or mediations. I don't think there's anywhere to actually even detail the specifics of what the services provided, whether it's speech therapy versus, mental health services or whatnot. So I think it would be helpful. I don't know how to do it. Without, we're already kind of discussing that this data, the only way to kind of obtain this mediation and due process data anyway right now is relying on the mediator or the due process hearing officer to check the box. If they don't check the box, or they don't consistently check the same box, then we're not getting the same information. If the one mediator is only checking the one major issue, while the other mediator is checking the three major issues, I don't know if we're getting apples to apples here. With the caveat, I think it would be helpful to have this information and maybe make a change. I don't know how we do it. And I'm certainly willing, to hear other people's thoughts on it.
Yeah, I think from what you were saying, it would be interesting, for if a particular school, for example, has had a number of complaints, to look at your complaints and what those issues were. Are the same issues coming up, whether it's complaints, mediations, or hearings.
Yeah, exactly.
Throwing this all together here. Are you having similar issues across all of these, or are they just all different such
Right.
that there's not a particular pattern or something you can,
Mm-hmm.
you know, can address?
And I think that if there is a pattern, I think the only way to fix the pattern, kind of without infringing on an individual's rights to make a complaint or due process filing or request for mediation, is just kind of education, whether it be to the school district and or the parents. And again, that I don't think is needed statewide because we have some really, really good school districts who are following the law, you know, and so those may be targeted training areas if we can somehow find a pattern at this specific school district where this same issue is coming up a couple times, you know, that targeted training is kind of the way to hopefully fix that pattern, whether that's DOE training or board training, I don't know. But I like the idea. I agree it would be helpful. I don't know how to best get that information to even see if there are patterns. I think it'd be difficult to find a pattern statewide, and how to fix that pattern, whether it be training or whatnot. I think it'd be, so I know that's very pessimistic of a statement for the topic of discussion. I just think it'll be extraordinarily difficult.
No, actually, I think it's genius because it becomes individualized at that point.
Right, absolutely.
Right?
Yeah.
In terms of the training. So I was trying to think through that. Sorry, I saw your hand
no,
go
that's
up, but
okay.
I was like, wow, that's, you know,
If
off
we
the
can
charts
somehow
for me, I think.
get that individualized data though, and I don't even know if that's possible.
We do have, our system, our iSham system is able to do a heat map as far as certain regions and it'll literally show hotspots on a map.
But we might be able to do a query to a particular school on those issues.
Yeah.
Do you want to come to our next meeting with our vendor and talk about some of these
I
things?
would be happy to. No, because honestly, if we can pull the data out somehow, it would be helpful. I mean,
Well, we'll send you an invite.
I would be happy to, yeah. I'd be
Or if
happy to.
anyone else is interested, we meet on every other Tuesday afternoon.
So, and I would also love, is there a way of digging into these others to see if there's any, what all is included into the others, to see what type of repetition is happening? I mean, that might be where the mental health issue
Yeah,
is
well-
coming up because there's no other place to check the box.
I think it goes back to potentially the training that the mediator and or the hearing officer receives, because they're the ones who electively select the boxes. I'm confident that there's a mediator and or hearing officer who uses the other category more than any of the other ones, you know? And I don't know if the way the categories are specified right now, whether somebody would even know to mark a mental health, because there will probably be services provided. I don't have the categories in front of me. You know, the appropriate services or whatever that category is would be the catch-all for probably all the services. So that's why I think if a detailed list would be helpful, if it's possible, and then maybe a retraining on those mediators and hearing officers to say, listen, this is really important because this is a good place and really the only place for us to get this information about the specifics of the complaints, to kind of get in those detailed lists.
Yeah, true.
And I think that's a great idea. I think in general, when we look at in 2018 and 2019, are two areas that have the highest numbers in both years or service or placement and provision of FAPE. So I think that those difficulties with mental health, just as Christy had mentioned, those come about in the way of we are in a disagreement about whether you're offering my child FAPE
Oh, absolutely.
and
Yeah.
or service and placement. So those are actually two of the things, along with not implementing the IEP as written, I could most certainly attest to. So if that could be broken down a little bit more, but with the forms that we have, that's how it's going to be presented, is my child can't access FAPE, or we're not in agreement about a service.
Well, I absolutely agree. I'm not, please don't take my comments as saying there's
No.
not mental health issues being disagreed about.
No.
I think that there's no global right now response to figure that out. So if we can break those down, I think the problem is, you know, how broken down do we go? Because it can get very specific on the issues, especially disability specific, you know, depending on the student's disability. But I think it would be helpful, if possible. Not that I want to keep throwing work your way, Dan.
I wonder about, we're talking about existing resources and existing data, but if our committee might consider something new, a new way to capture data. And one thing that came to mind for me would be a potential reflection after a party's been engaged in a complaint or a mediation or a due process request. a reflection with the family and or a reflection with the school, whether that can be combined or separate, kind of like an exit interview when somebody's leaving employment. And if we could utilize that in a qualitative study way to get to some of the root cause issues that sort of led to the disagreement. Because I wonder if we're going to get into the areas like lack of resources for children that have mental health needs, or it came down to a funding issue and somebody needed to fund it and we couldn't get the insurance or the school or the, X person to pay for what that child needed. And, if we could really dig down into the root of, there's a lot of broader context to why I feel like there becomes disagreements. And if we could start to identify those, then we can use those as platforms as leaders in our state amongst our different agencies to advocate for change in those broader contexts too. So I think that'd be interesting.
Dana, are we able to, this may be a dumb question, but I've always been on the user end of this from a school standpoint and as a parent standpoint. Are we able to, what's the latitude of changing to the point of, do we even have the right boxes there to check, right? What is our latitude? Can we, is that something that's set by the Fed somewhere? Can we do whatever we want on that? What's that?
These check boxes are set by us internally, okay? It's a matter of, it'll cost us some money to pay our vendor to change it. But
Okay.
we're not constrained by any particular federal requirement or anything. This is the way we've tracked it. And like I said, it was something that from our paper forms many years ago. It's just
Okay.
kind of an outgrowth of that, and we kind of continued along with what we were doing before when we went electronically.
And I assumed so, but it seems to me that while that probably seems to some that we're going outside the scope, but if there are tweaks that make the rest of it better, I think sometimes we have to go there, right? So I think I put that in my notes of something that we really need to look at and come back to. That's been a great discussion from that standpoint. And then back to my first thing, this theme of training continues and consistency continues to come up, right? If Pat and I are both doing hearings, if we're not checking the same stuff and doing it the same way, that's problematic for us to then go back and do that. That's huge for me, so I bring it up again because I think it needs to be used for us, right? From that thought process. What else? Anything else related to, I think we're on part B still at this point, right? We did come up with a lot of discussion.
I think the other comment Tom's made that's important is that a lot of schools do this the right way.
Yes.
And a lot of schools don't have issues.
Yeah.
And I don't want us to paint a broad brush here that everybody gets kind of thrown into that same barrel, but I think somehow as a school corporation, we should have to report yearly all of this. I mean, it may be building a whole new software program for us to report it. What happened? Why was there a complaint? Where did we get to? Because that is too big of a monster for you to be able to do, and to just expect hearing officers to be the only ones that get us there. We have over 2,600 special education students in Perry Township schools, and there's no way I think we can get the data that we're talking about here just through a hearing officer process. It's almost an individualized, if we had a dispute, let us report it. The dispute may be mediation within our own school district, but don't we want to know that? Because 9 times out of 10, this is all going to come back to services dollars, because where we're heading is the mental health thing that keeps coming up. I don't have enough money for that. I don't have enough money to give the students who deserve these services, those services. And that's where we're getting into the disputes. We've got to have something legislatively that has some money there to address that issue. And right now, there's a lot of school districts that are small that probably are causing a lot of this disputes because they just say no. And it's a financial decision more than them wanting to help kids. And I don't know how we capture all that data without maybe just starting a new software that we can submit to the state so that you can gather data from all of us. Because right now, I don't think we do a very good job of that.
When you wouldn't have the formal data to support
No.
what you're saying the need is,
Yeah,
right?
exactly.
Okay. Good.
So I think if we're checking boxes, we gotta check boxes. What caused the dispute? And if the district says it's money, then let's find that, because then we gotta be able to go to the legislature and say, not only just the state legislature, but the federal legislators, and say, we have to have dollars coming in to address this. You know, when I worked at the state, we reverted a lot of SA5 money because we never could get it accessed because there was too many restrictions, not enough flexibilities to serve students with it. But we don't do a good job of collecting that right now.
This is off topic, and based on my ignorance alone, placement issues. Is the school district solely responsible for those costs, or is that something that you tap into DOE for, funding wise?
Are you
How
talking
does-
about the what we refer to as the S5
Right.
placements? Those are funded almost entirely by the state.
So if it's something that the school district determines in the process that this is a needed service to,
Yeah, it's typically, you know, students placed residentially, or
Right.
sometimes their excess costs, they're really high cost, you know, placements. Some are, you know, students are still kept locally with additional sources there. Probably the caveat for the schools that makes it sometimes difficult for them is that the case conference committee has to determine that these are the services that the student needs.
okay.
And then the school submits an application to the state. And when they submit that application to the state, they are supposed to have already found the placement that would be appropriate and accept the student and whatever, and have a budget attached with it. And then they're always afraid that what happens if the state denies the application?
Right.
The case conference has already decided the student needs these services, because the school would be on the hook for that.
So the
But
plans normally
realistically-
agreed to and signed before the application is submitted to the state?
Pardon?
The plan is signed and
Yeah, the case
submitted?
conference has to be in agreement on this, and then they submit the application. And almost always the applications are approved, or if there's something wrong with it, then the state will work with the local school and say, hey, you need to fix this, that, or the other. But, you know, last year, we went through a process where we were running out of money on that, and had to cut back on some of the types of services that we would be able to approve, and that caused a lot of problems. But the state had a year's worth of meetings with, you know, various directors and other interested parties. I'm not sure were you on that committee?
I was.
To come up with some recommendations about how, you know, what types of services will we be able to fund with this money versus, you know, having to not do certain things, so.
Was that, when that change was made, was it going forward, or was it based on the ones that have already been approved and adjusted down, or how was that?
Well, I think things that were already approved and we had contracts in place, you know, were honored, but going forward, there were some things that we, you know, there were, ABA services were not funded, some summer school, extended school year services were maybe not, because a lot of the residential placements were just automatically put in for a year without the case conference actually making a determination of the need for extended school year services. But because there you had the concern is, if I give up this bed, okay,
Yeah.
there's no guarantee that the
Right.
facility is gonna have a bed available for me 2 months later when I need to come back. So it was a mess.
To go back to what Pat was saying, I think also from the parent perspective, they would also want to be part of that exit interview, or however we want to term it. I know as a complaint investigator, there are a lot of parents that I've worked with, and rightfully so, where if there was some sort of index at the end or some sort of this post discussion, they would want to make sure that their point of view is heard as well.
And the reasoning might be different.
Yeah.
What the parents view is the reason that we're here versus the school's view of the reasons we're here may differ.
Yeah.
Yeah, and see how far apart those are.
Perfect. Anybody else, anything there? Okay. Let's move to our part C, a discussion, Dr. Balsey, you've given us some info and dissertation, you've got some points that you'd like to make. I'm going to turn it to you.
Okay, absolutely. Well, when Tim called me on Monday afternoon and said, hey, Angie, would you be willing to share some of the points from your dissertation with our group, I was honored, as well as I spent a lot of time thinking about what an interesting situation, because here I'm a researcher and I have a very particular lens through which I research this issue. I'm also the representative from iCase here, and I speak on behalf of the state, yet I'm a collaborative member of this problem-solving team too. So thank you for your patience as I toggle back and forth between the different hats here. I've pointed out my positionality on this committee as my role as a director, and then also just that I am a family member of an individual with disability and disabilities. My uncle in middle school was dared by a family friend to pull the fire alarm, and that was the end of his public education. And so my grandparents were left to continue to educate him through their own means. So I understand the issues that families face. And so when I approached my research, I had two research questions. One, I wanted to know the proactive leadership actions of special ed directors to prevent getting to the point where families felt like they needed to be in a conflicted situation. I wanted to understand that better. My second research question was about the period in time between when a request for a due process hearing is filed and when it's resolved. That was when I dug through extensive amounts of empirical literature to prepare for this. I didn't see much on that period of time. In fact, most of the literature was around outcomes of hearings, but nobody was looking at when a request was made and then it's resolved. In Indiana, that's 95% of our hearings, roughly. I felt like that was a really prime opportunity in that resolution process to study. So that's really the two research questions that I have. I used a micro-political conceptual framework which just acknowledges that conflict exists, it creates adversarial relationships, it impacts the allocation of scarce resources, and that actors work to build collaboration. So I'm just gonna flip through here. Historically, conflict exists, that was part of it. Started back with the civil rights movement for individuals. That sort of gave the impetus for the Park and Mills cases. You're all pretty educated on those topics around this table, so I'm not gonna dig into that. Those were about procedural rights. More recently, our federal and Supreme Court cases have been about substantive rights. We've been acting under the Rowley substantive standard for a long time until more recently the Andrew outcome, in which we look at appropriate progress in light of a child's circumstances, and that's the substantive outcomes that we look at today. And so when you've got, a family member who wants the best for their child, we all do as parents, right? And then we've got a school system who looks at what is educationally appropriate, and that A in FAPE is really where it comes into light and the conflicts tend to exist. And then also, what do we see in an educational setting? That's what, as school districts, we are required under law to work with for the children. So conflict exists. Flip forward here a little bit. There's a qualitative case study. I'll be a little bit of a research geek here for a minute with a single case design. To collect the data, I interviewed 10 special education directors from across the state. They represented a variety of large urban down to small rural districts. And it was coded for thematic analysis, and it's got all the traditional aspects of validity. Limitations. It's very important that I say that this is the perspective of special education director. There's a huge limitation in this research that I didn't talk with family members, I didn't talk with attorneys, I didn't talk with school administrators or teachers. This is just from the perspective of a special ed director. So I want to make sure that that's very clear as I go about that. So research question one about the proactive leadership actions of special ed directors. Relationships are critical. The relationships that we all have with families and within our schools is really important to not get to a point of conflict. When directors work to understand the concerns of parents, they're more likely to be able to resolve concerns around the case conference committee table.
when all of our stakeholders are trained, when our teachers know what to say and do, when they know how to write quality IEPs, when our principals can recognize signs of concern that arise for families around the case conference table, and they can appropriately address those concerns as they arise, we end up with less conflict. Also, when alternative dispute resolution is utilized, we are more also able to engage with families and resolve concerns. So those were a lot of the proactive leadership actions, and I just wanted to acknowledge that I appreciate there's been, we have a lot of great schools out there, and we have people working hard. So even when mistakes are made, it's not that people want to make a mistake, but there is a need to continue to train our staff, continue as special ed directors and leaders in our state to be proactive and to continually refine our practice to be more proactive. And that was a part of my research question 1. Research question 2 is directors' experiences when receiving the request for a due process hearing, and really 4 main outcomes for that, in that they received requests unexpectedly. And I know I mentioned that last time. And usually when you know about a concern and you can get to the table and talk it out, what my participants told me is you can resolve it. But they talk about coming back from a meeting and finding a request for a due process hearing on the fax machine, and they'd never known about this family or this concern. Also, that alternative dispute resolution was unproductive after the request was filed. After a request for a due process hearing is filed, parties have the option to engage in mediation and/or resolution session. Most don't engage in mediation because there's a 15-day timeline in which you have to respond to the hearing request. So folks will participate in a resolution session. That's very common. While there can be some great dialogue at that table, and typically there aren't attorneys involved in that process, the participants in my study said that the resolution process is worthless because families are coached by their attorneys not to agree to anything. They walk away from the table, and though that was put into the law in order to try to shorten the timelines. Like, our commitment here in this group is to bring about efficiencies, cost savings, collaboration. The resolution session was added to the law for those very same reasons, yet that process isn't working out right now. That was one of my recommendations for further study too, is that we dig into resolution sessions and study that. We as researchers, we as a collective, nation of thought provokers about this. Is it working out the way it was intended when it was added to the law? My research, which is one study, says it's not. It's not meeting the needs as it was intended. Also, I delved into the settlement period, in which what do directors think about when deciding to settle or go on to a hearing? And a lot of it came down to cost-benefit analysis. They're weighing not only the actual dollar amount associated with going to a hearing and paying for attorneys on both sides of the table, because that is the school's responsibility, is to pay for both the school attorney and the parent attorney. So they're weighing out those costs, but they're weighing the cost of the relationship too. They're weighing the cost of the time involved on behalf of the decision for the child. They know that these things can be drug out for months at a time, yet that child's still coming to school every day. That teacher's still engaging with that child, yet many times when we're engaged in a due process hearing, parties aren't speaking to each other. And so that time that passes, that's another cost that they're looking at. Also, as importantly, is the cost to the relationship. Sometimes if you can just be like, okay, fine, let's settle this, even though you kind of feel like it isn't something you want to settle on, you might, the people in my study said that they would settle it just because they wanted to rebuild that rapport and that relationship, to keep working together on behalf of that child. Additionally is the stress on the staff. No teacher goes to school and, is ready to be a third grade teacher, a special ed teacher, to be like, I want to be put on the stands and cross-examined about something that happened in my classroom 24 months ago by expert witnesses. And this is a little bit what I alluded to in our discussion last time about this is administrative procedure. Why has this become court? Why are we following trial rules when we're talking to teachers and families here to work this out? So that strain and stress, this isn't part of my study, this is a side note, but educators have left the field because of they've either been involved in a due process hearing or even just the fear of the shadow of the law that they could end up there and they don't want to. It's incredibly stressful. Again, remember that the point in time in which I studied was before it even goes to a hearing. So one of the things I found was that all of the documented research about this is the impact on people when you go to a hearing, those things still exist in a request for a due process hearing too. Because before you settle, attorneys are coming in and doing witness prep. They're coming in, sitting down with our teachers, and it's, I need you for 2 hours, I'm getting you a sub. You're going to sit with our attorney and do witness preparations. Really? Like, they should be in the classroom teaching our children. Not, even when it gets settled, those things happen. So that stress and strain that it causes for them on that. There's the cost of lost instructional time, the cost, involved in the time of the director. Directors in my research said, I put everything else on hold that I'm doing. So right now where I want to be an instructional leader, where I want to better practices in my organization, I can't. I put everything on hold and this becomes the priority for months on end. And I spend all my time preparing for and responding to this. The hours and hours of preparing documents and going back and all of that. Also, the last point under this research question 2 finding was the negative experiences with parent attorneys. One participant said it was like Perry Mason, where, the parent attorney comes in, slams the folder down on the desk and sits back and says, now what are you going to do about that? And so I was interested in that. And I had to return to my lit review a little bit with the guidance of my dissertation chair, Dr. Janet Decker from IU. And I dug more into the role of the zealous advocate. And I wasn't aware of that. I'm a teacher by nature, I'm not an attorney, so I learned a lot about this. Attorneys are trained to be zealous advocates on behalf of their client. They're trained to get the best outcome for those that they represent. Whereas special ed directors, school administrators, we're just trying to come up with a collaborative solution. So when you've got a collaborative solution leader up against a legal zealous advocate, that's sort of a conflicting role too, and there's really not a benefit to the parent attorney that's representing a family to be a collaborator. Like, their role is to get the best outcome for their client and to utilize all their tricks and strategies and tools that they were taught in attorney school. School staff experience that negative interaction with parent attorneys. They're likely just doing their job really well in a lot of ways, but again, we're teachers, right? And that's not what we're trained to do. So those were some of the outcomes from my 2 questions. So I had 3 real recommendations for practice. One is to build the capacity of special ed directors to be proactive leaders. That's a continual piece that we always need to be working on. And as ICASE, with our mission of advocacy and support and leadership in our state, that's something we always work on and we put at the forefront of our professional development. 2 is to reduce the involvement of attorneys. Sorry, Tom. we appreciate you. How do we use you proactively, right? But keep attorneys out of it. Families and schools are able to work together so much better when we don't get into all of the legalese and all of the procedural practices that come along with law. And then this is not allowable under federal law. I will go ahead and say that, but require was my research recommendation, a tiered system of alternative dispute resolution. Require that we utilize lower forms before a due process hearing can be unexpectedly sitting on our desk. I didn't mention this, there's a lot of details I didn't mention. I spent 2 years studying this, so there's a lot more I could mention. I'm trying to hit the highlights here, is that over and over I heard that from the moment that request hits the director's desk, it's a minimum of $10,000 no matter what they do. Minimum. folks, we're talking taxpayer dollars here. That worries me as a steward of taxpayer dollars, that as soon as that request hits the desk, we're $10,000 out the door. That's the cost of an instructional assistant, a part-time one probably, but anyway, that aside. Also considering a lot of the folks in my study mentioned, one particular group of attorneys that was very contentious, they felt, and that was mentioned over and over. So anyway, keeping attorneys out of it, requiring alternative dispute resolution in a tiered system. Future research, I already talked about the effectiveness of the resolution session. I'm really intrigued about the idea of the role of the zealous advocate and how we could look to family law and the practices that acknowledge that a child exists in the middle of this dispute, and we need to keep focused on the child and how can we maybe minimize that role of the zealous advocate a little bit, and obviously include the perspective of other stakeholders around this topic was the area that I have. So Dr. Ernest said, he's like, I was wishing you had some great ideas for what we could do, and that's definitely why I'm a part of this committee here, and I've got some thoughts here, but I'm going to just pause now, because that was really the summary of my research, and not jump into these ideas I have for change. But anyway, so I'd like to entertain some questions around this as well.
I think they got rid of the zealous word. Didn't they get rid of that out of the rules of professional conduct? It's been all,
Yes, they did.
Yeah.
It was in there when I started as a lawyer, but it's not there anymore.
I'm glad the word is gone. I'm curious about the practice.
Well, the practice is still there, I'm sure. The word was removed for a lot of the reasons you talk about, is that it led to a lot of incivility.
Your comment about mandating alternative dispute resolution, and your comment that that's not permitted currently by federal law. So are you aware of anything at the national level that might suggest this is something that needs to be presented to Congress? IDEA is under that constant perpetual reauthorization.
Sure.
15 years in the making.
So again, is there anything that you've seen that would suggest at the national level, we have other states suggesting this. Can this get legs nationally, I guess is what I'm trying to say.
I'm certainly intrigued by that. I do know there's work through CASE and CEC. The Association of School Superintendents has a white paper on proposals to reauthorize IDEA. COSA, the Council of School Attorneys, is working on some suggestions to that. So a lot of times there's pushback there, though, because not wanting to interfere with parent rights to get their concerns resolved. And personally, I don't see it as interfering if we at least have an opportunity to resolve the issues on the front end. And at least I'm going to speak out of turn here because I'm not an attorney, and more of you around the table are than not. But like a tort claim, I think folks are able to say, hey, I'm really upset about this. This is your official notice, and you're given 10 or 15 days to resolve it. And in Indiana, I think we tried to enact, I think it was 1420, and where we attempted to say that parents first had to make schools aware of their concerns and schools be given the opportunity to resolve it. I've had personally experienced a request out of the blue. I tried to state 1420 in the defense of our case and didn't work. There's been pushback on that. I still disagree with that. But so that would be, potentially looking at something around a tort claim, an opportunity before it gets all complicated, that families can say, this is what I'm unhappy about and what I want, and for schools to respond to that, and to keep it at that level between just families and schools. And I would be very interested in being engaged in state and national advocacy around that.
Well, I just raised the question because since I'm here on behalf of school boards, I know the National School Boards Association has as one of its legislative priorities encouraging the reauthorization of IDEA. So, if there would be national support for something like this, then there may be that opportunity to interject that in the federal statute.
And that's part of what I love about all of these different organizations sitting around the table today and through this work is that we have to come together on behalf of our children in special education, in public education. There's so many different ways. And recently I was in DC advocating, and there was a couple other national groups there, and it was fully fund IDEA. That was the message you heard from Council for Exceptional Children, school business officials, State Superintendents Association, and nationally. There's lots of reasons. We heard of one earlier, why we need to fully fund IDEA. But I think you're right. In policy change, us having a unified voice is the one way we're going to be able to get a difference in that.
Lisa, you all put a group together. You're all working on this too, right? Have you put a group together to be looking at special education?
Our association?
Yeah.
No.
Okay. I thought you had for some reason.
Sorry.
First, Angela, thank you. To condense 2.5, 3 years of work into 15 minutes and concisely present it, I commend you. I was impressed with that. But I do want to say from more of both the practitioners, as a former superintendent now representing, the resolution process is a good process. But what in my experience is, it goes right along with the research, is it's the perception that all parties come in with before the process starts. There are a number of good attorneys, just like there are a number of good schools. There are a few attorneys that are probably motivated more instead of advocacy for money, just like there's a few school corporations instead of advocating for the child, they're looking to cut corners. We'll acknowledge that right up front. But there's not an opportunity in an informal process. My experience has been generally when there's a third-party advocate, a friend of the family, someone that comes in that does not have a financial interest or a perceived financial interest.
Absolutely.
Resolution is reached, if not within hours, within days, to mutual satisfaction of both the school and the parent, but more importantly, to the benefit of the child. So it's that perception sometimes that, well, we're stretching this out. The insurance, I mentioned this last time, insurance folks say, we're going to settle. And then when you say that, then there's a perception on the school's part that we did something wrong. So there's a hesitation there. So there's this unfortunate sense of anger that comes with these perceived or misperceived intents of why people are around the table. To go to, again, your kind of recommendation here of kind of a tiered system, I think if we can find that entry level of resolution where we try to work through and minimize the perceptions of why everyone's around the table and really come to the focus point of we're here to find the best support for the student that the school can provide, that whether, and we talked too about some of the cost sharing. Once the case conference is determined what the needs are and the services are, school's bound by that. We certainly want our state DOE to help us fund that, but when we send that application in, it's always with the understanding there may be a loss of funds, there may be something else, but yet we're obligated, as school corporation, public school corporations are obligated to provide those services. So I concur wholeheartedly. If the one result of this committee, Dr. Ernst, is to come up with this hostile-free resolution environment at the entry level, I think what we would see is a large percent of settlement before it ever got outside of the school system, and the parent would walk away. And maybe not everybody's 100%, but there's mutual understanding that what we've determined is in the best interest of the child. I apologize, I do not have the solution to how we enter that start of the resolution process with a level playing field, a common focus of doing what's best for the child. So I don't, so as I'm reflecting, reading some of the notes that Tim sent, I'm thinking, here's what I would like to see happen right here. How do we get to that effective, efficient process that expedites services to the child?
Absolutely.
And then once we can do that, if this committee it reaches that, you're more impressive than anyone else I've sat with in a long time. So
We'll be high-fiving each other, right?
We will.
Well, it's an HFRP, a hostile-free resolution process. You just call it.
Hostile-free.
That's what we're after.
Thank you very much.
Or collaborative, yeah.
All right.
Wow, another acronym.
But I do want it noted, I did say there are good attorneys as well, so.
There are,
It's,
there are.
please put it on the record.
Yes, I'd just like to follow up with exactly that. There are many schools doing wonderful things and many attorneys that come to the table trying to come to a resolution. I would like to piggyback again on the discussion about education and collaborative training, because Angie, just as you're talking about that zealous parent attorney, parents feel that they are confronted with a zealous school attorney. And I totally agree. If we could perhaps consider, and I know I'm not even really part, I am just Joel for today. But over the years that I've been able to do this, and as InSource walks through that process, trying to be that neutral person, many times that imbalance of power when a parent comes up, I do believe sometimes their response is perhaps a step up. And if we could continue to look at what kind of engaged education for both sides, many times even together, to help families and schools understand what the issues are, to ensure that schools are following through on the training so that the general ed teachers, the special ed teachers are walking through those IEPs in the way that they're supposed to, so that parents know that that's done, and so that parents understand the limitations and what is involved in IDEA and Article 7. Because I do think sometimes the complaints and things that are dropped, or when they come to us, we will say, well, that's not really special education issue. We will, of course, explain and to say to go to your director, to go to your principal first, to go to your director, to have that discussion, because it's so vital that that doesn't just show up on the director's desk as far as that. But I do think if we can look at those three big issues of the IEP not being followed, child not being able to access FAPE, and where services are, if we could look at combined training so that both parents and schools work together in that system, and that knowledge of being educated and coming to the table together, perhaps that would help with coming with a more even playing field, because I do think sometimes that's what occurs with that shift of power. Well, if I don't have that power, I have another way to get that power, and that's how I'm going to get it. So in that collaborative spirit, I would encourage some continued intensive, intentional education between parents and school districts to be able to understand that process in IDEA and Article 7.
I think this was the third time I've read it, because I read it the first time when you gave it to us during the legislative session. And I think I'll start off with is, I don't disagree with your three recommendations. I think there are good places to start. Sometimes when I've read through this, there were sentences that agitated me or rubbed me the wrong way a little bit, just because I'm coming at it from the family perspective, and I completely understand and appreciate your lens very much. But I think we could easily put families in the same role, because I think they would say the same thing. We need to talk specifically about the stress put on teachers and special ed directors of preparing for court. Parents certainly don't like that either.
Absolutely.
Parents want to be spending their time at home, supporting their child and making sure their child is getting the same thing. So I don't think we are at complete opposite ends. I think we are so close to wanting the same things. We just want to do it differently. And the word appropriate, I think, is so subjective, because what a school corporation might think is appropriate and what a parent feels is appropriate. And I don't know how we answer that or solve that problem. But I think we just need to remember, we could have easily had something written or stated from Brandy, who unfortunately isn't here today, who probably would have stated all of the same reasons why this is such a horrible process. But just from that parent perspective, that again, it's very close, but just a very different avenue to look at it.
Thank you for that.
I will admit, and I'm going to, but it's been a busy week, so I have not read it fully, but I intend to. But I appreciate the very quick 15-minute summary of the 2 years of work. It's been excellent. A few comments I wanted to make. The research mentions, and you mentioned that the dispute resolution period following the due process filing hasn't been working. I will say the caveat that I think a lot of the reason we're here is because of a few bad eggs, I think, okay? Those, whether they're families who want to push, whether they're attorneys who want to push. There are good attorneys, there are good school districts, there are good families that just want services for the kids. The numbers that Dana provided indicate that the resolution period has been working of some standards. I mean, we don't have anything more recent than 2016, 2017, but if you look back, 2011, 83%, there was a resolution following the meeting. 73% the following year. 80% the following year. 83% the following year. So, the resolution period that was built into the law generally does appear to be working, that things are being resolved there. So I absolutely don't dispute that there are attorneys who may be coaching their families to say, this is a step we have to sit through. But it does appear that resolution period by the numbers has been fruitful. I mean, that the purpose of that was to quickly, within X amount of days, sit down, talk about the issues, and come to a resolution. And, with the exception of the 2016, 2017 year, the vast majority of those resolution meetings that were held resulted in an agreement. So, I will kind of add that to the thoughts. I'd be curious that the 10 special ed directors that you interviewed, having only an average of 1 to 4 to 5 due process hearings held per year statewide, I'd be curious on how many due process hearings they have experienced.
I might have had that in there
Okay,
because.
and I'll find out, because I will read it.
Yeah. It's been a bit since I've written it, but yes, I'm pretty sure that's in
Okay,
there.
I was just curious, because, with
Some
them
had
being so few and
experienced
far
several,
between.
and some I know had experienced a few.
Okay.
But yeah.
And then the last thing, and I 100% appreciate your lens, and that's why I'm really interested in reading it, to get the kind of the special ed director's take on it, because certainly is different than my take. You mentioned that the minute a due process is filed, that it's $10,000 minimum. A lot of the majority, I would say, in Indiana that are filed because they truly feel that they aren't receiving the services that they should receive. So I know it's important to talk about money with the school districts here, but on the reverse side, we're talking about the kids' civil rights. So many of these are filed. Most of these are filed because the parents are feeling that their kiddo with a disability who has a federal civil right to receive appropriate services, that very subjective term again, aren't receiving it. And again, I think the majority of those aren't the out of the blue filed without trying to work with the school. I think the majority, I would say, are trying to work with the school, and there may be just a fundamental disagreement on what's appropriate, what they're required to do, and what they think is needed for the child. So I understand and appreciate the take on it's a $10,000 minimum as soon as it's filed, but there's a lot that goes into that, especially emotionally, for those families to take that step to file it, and they're filing it because it's their federal right and their federal civil right that they're trying to provide the appropriate education and try to challenge the school on receiving it. So, again, I know that we can't just completely take money out of it, but on the reverse side, we have that. So I wanted to mention that as well. And then finally, the required tiered system, I again want to reiterate, we do have that tiered system in Indiana. It's not required, nor can it be. But I forget what the acronym is. What was
HFRP.
Maybe the HFRP is the mediation. It should be. A mediation is not an arbitration. It's supposed to be that low level, low stress. Hey, let's sit down. Maybe the case conference is it. That should be a low level, low stress as well. So we've got the case conference, right? That's created for this purpose. If we disagree, we've got the mediation, which we've created for this purpose. If we don't want to go through due process, we've got a complaint procedure where, we have very qualified investigators who, from a DOE standpoint, can look into it and kind of and try to get there. So we do have that tiered system. I think we have that no stress option. And I think a lot of those, and we have some of the numbers to look into, of those families exploring those options first before they're jumping to due process. I would caution sometimes when there's a tiered system that is required, it becomes a rubber stamp. And I would, as an example, if anybody's familiar with employment discrimination from ADA Title I, if you feel that you've been discriminated against by your employer, before you go to court, you are required to file a complaint with the EEOC. If you want a right to sue letter from the EEOC, you get a right to sue letter from the EEOC. It's a step you take. And it is oftentimes a very delayed step that isn't necessary. But it's that required step. I can't go to court right away and say, I'm gonna file a lawsuit against my employer because I feel I've been discriminated against. I must file a complaint with the EEOC first. EEOC can investigate, they could find, yay or nay, but at the end of that, you get a right to sue letter, which gives you that ticket to court. If some of these families who have gone through the process of trying to solve their issue and really want to work with the school have gone through maybe some of these lesser steps, that's probably just going to be a step before they're going to file due process anyway, because if there's a fundamental disagreement on what's appropriate, what is needed, that's not going to end there. I mean, it's sometimes going to take that due process filing, unfortunately, to come to a solution. So, again, I look forward to reading it. But from my lens, I kind of wanted to add some of those notes and some of those thoughts based on.
I appreciate that, and I would love the opportunity sometimes just to dialogue with it. When I was talking and you were talking, there were things that we could have I'm interested in more about that.
Yeah.
You're absolutely right, and it's a civil right, and it's kind of the one civil right that we've left in the hands of parents to follow up on.
Mm-hmm.
Other civil rights have other ways for it to be figured out and mediated, but we've left this to parents to do, and that's just not a good situation for families. When I said that the resolution session isn't working, you're right in the numbers, and sometimes I think our policymakers look at the numbers and they say, good job, Indiana, you had 86 out of 95 that resulted in a resolution. And we talk about other data we might collect. I think we should collect data on how long it takes to get there. Whereas when you sit down at that resolution meeting within 15 days, to be able to sign an agreement and walk away from that and awesome, we agree. Let's put these things in place for the child tomorrow. It gets extended into 6 months. And almost every time there's a request for a filing extension and we end up okay, we've offered this. And then a couple weeks go by and I have to call up our attorney. Have you heard anything? No, I haven't heard anything from their attorney yet. And in the meantime, days are ticking by for the child in school, right? Mm-hmm. So when I say it's not working, sitting down in that initial meeting very rarely results in a written agreement. I've had 8 requests that I've personally responded to. The first couple times I had an agreement drafted. I saw the demands of the family and we worked it out. We figured out what we were going to do. I drafted it so in the meeting we could do that. Recently, I've been coached, don't even draft it because nobody's going to sign it. Nothing's going to come of that, So that's where I'm saying it's not working. Mm-hmm. We have an opportunity in a short period of time to do it, and that short period of time is not happening.
Thank you.
Who's giving you advice to not draw it up and sign it, or to draw it up?
Well, it's really just it's not going to, I've had a draft, but it's just I think on practical purposes, it's become I kind of anticipate it. I was hopeful in the first few, hey, this is gonna work out, but then now it's it's not gonna work out, so it's not, I haven't, it's not a formal, ready to go piece yet that I have, so, yeah.
When Tom was talking, it reminded me of a question. So you had brought up sometimes you get surprised when something's dropped on your desk because you aren't aware of it. Can you educate me for a second of, being a special ed director, whatever your caseload is, how many teachers of record that is. So are you communicating with them on a regular, because they should not let something fall on your desk that you aren't going to know that's coming your way, right? So they should be able to tell you on a regular basis of, hey, we're having a trouble with, this kid, trying to, get him the appropriate resources to be successful. What does that what type of communication, what does the communication look like between you and your teachers of record within your corporation?
Yeah, that's a great question. So let me answer that personally, what we're attempting to do, and then kind of more broadly. We're trying to have a cover letter to go with the procedural safeguards that has a short little paragraph. Hi families, welcome to special education. This is a collaborative, interactive process. We want to hear from you. We want to hear your ideas, your concerns, your visions for your child. Please reach out to these people. And then we have 4 people on the page with their picture and their contact information of the teacher of record, the building principal, the local district special ed director, and then myself as the co-op special ed director. Because a lot of times I think why directors don't know is because parents don't know that we exist, right? Sometimes after it's filed and we engage with them, they're like, well, if I'd have known you could have helped me before this, I wouldn't have got here. So that's part of that proactive leadership. What can we do? So the way we're trying to approach it in our cooperative is one example of that. And I've shared that out as I've presented, and we're trying to build that capacity of others as a way to do that. So another thing then, back to my research, when I was looking into what are the proactive leadership actions, and I asked my participants that, one person specifically spoke about trying to scale up the information. So if you're in a small district, it's fairly easy. But when you're in a large district, Perry or others, that are very large, getting that information from the case conference committee where a principal's chairing it up to their special ed director that really has the skills and knowledge to resolve it. So that was something that participant talked about, was training his folks to scale up and down information too.
Yeah. So you're explaining it the way that I thought you would, but I don't think the burden is just on the parent. So even if the parent gets something that says, here's the 4 people involved in your collaboration, it still should be up to your teacher of record to then go to their special ed director to say, we're not being successful with this kid for whatever reason. So the burden's just not on the parent.
Yeah, absolutely. We
Okay.
also train on knowing the red flags. That's just the title of the slide in the training. But it's starting to see where, train on like body language, train on like when a parent inquires about a different topic that we haven't heard before, or if they've been calling you Angie all along and all of a sudden you get a Dr. Bosley letter, like that's an indication that, like, all right, we need to escalate this. We need to realize that these people are unhappy, kind of thing. So we do train on what are those signs for people to pick up on in a meeting, to let the director know as well so they can engage earlier. Yeah, good questions.
I have a question, Earl. So one of my frustrations a lot of times in the space that I work in with state board type things is that we end up a lot of times working in the space of how do you, Dr. Taylor called them bad actors. How do we take those out of the equation, right? And sometimes I think we spend too much time on that, but it as I say that with a caveat, because Dr. Taylor also, I one of the most memorable times when he came and spoke to start a school year when I was teaching, he told us, you as teachers do not get to have a bad day. You remember telling us that? And at the time, I thought, gosh, how do you do that, right? Like everybody has, out of those 180, but it's also caused me, as I was helping our schools start school this year, I was telling students, hey, I'm sad because we only have 179 of these left, right? It's all in your attitude, right? So, but my point is, how do we get to, because I think one of the charges of this is, how do we get a process to take the bad actor piece out of that? And maybe we just can't, right? So I'm trying to redirect the question of because we can sit here and pat ourselves on the back, say, hey, there's good people, there's good, bad people, whatever. But I think what we need to get to is how do we put a system in place? And training's part of it, all the things that I want to talk about at the end. But then how do we look at, do you all look at yourselves? How do we look at schools to know that, hey, we're doing the right things, telling our people who the folks are within our school and that piece? I think that I'd like for us to think for a minute, what's that look, which then gets to your point, right? Of how do we make it be a
HFRP?
Yeah, exactly. And I'm even forgotten that now at this point. But how do we get it to that point with that? Because as a school leader, I also know realistically, because I've had people remind me of this as we're looking, I'm not going into things without having talked to my school council, because one, my school board is going to tell me I've needed to do, they're going to want me to have done that, right? Now that doesn't mean I necessarily have to have them sitting beside me, and nor do I think a parent, if they're doing the right thing, I'm probably not going to have done that without that either, right? So I'm having real trouble, I guess, reconciling after this discussion. How do we get to that? And I asked you specifically because I think because your thoughts kind of gave some, because we're not looking at huge numbers of a problem.
Yeah.
If I was a big industry to look at the numbers we're looking at, it's like, man, don't spend any time on that because we don't need to fix it, right? Not suggesting that, right? Because I've always said if you have a 99.8% graduation rate in your school, you probably have one that didn't. What about the one, right? Because that one is important. So please don't take this that I'm taking, but how do we make this real into help that? And sorry, that seemed like a dissertation in and of itself, but that's where I'm having real trouble reconciling. Do you have a response or thoughts?
Yeah, I think if I knew the answer to that from a global standpoint,
Well, we wouldn't be here, right?
Yeah.
well, I would solve a lot of issues. I think it's twofold. I think that we've acknowledged there's good attorneys, bad attorneys. There's probably good families, bad families. There's good schools, bad schools. From the school standpoint, it probably goes back to training, and having good special ed directors, and making sure that everyone in the school is trained on kind of what's appropriate in FAPE and IDEA and all that stuff potentially.
And probably available resources.
And available resources as well. Yeah, absolutely. I think it goes with training. On the parent side, I think it's a very difficult question. I 100% agree that these are small numbers, and like you mentioned, in an industry where if this was the issue, it probably wouldn't be looked at. And I think building off that, I think it's important not to kind of blow up the system to try to fix the few. And I get your 99.8 example. This is not an issue that is limited to special education. If you look at it from my lens, okay, from a disability rights standpoint, this is an issue that is in the news with service animals, okay? Everyone acknowledges that there are people with disabilities who absolutely need a service animal and is very beneficial. And then you have the person who brings a peacock on an airplane. That does nobody any good, okay? And it certainly doesn't do any good to the people who need it, right? The same can go with, parking lots, right? You have really bad attorneys who are sending out letters demanding parking lots be fixed from out of state, okay? That's a bad actor. But again, kind of looking at the reverse side, these are civil rights. And so we need to make sure that we're not making changes that are infringing on its civil rights of people who truly desperately need these services to combat the bad actors. I don't know the solution. Those two examples that I mentioned are still being discussed. We don't know, we can't outlaw, nor should they outlaw service animals because people need them, right? But how do you deal with the bad actors? So I wish I had a better answer. I would just again caution that I think that if we're looking at due process filing specifically, let's look at the number of total students we have in special education. Let's look at the number of districts, and let's look at the actual number of filings, let alone the hearings that are 1 to 5, And I know those cost money, but how many of those are truly being, put forth and going through the process because they feel their kid needs those services? We can't blow up the system to fix the bad actors. Right. And I just don't know how to prevent that. But it's, I'm certainly open for discussion. If anybody has thoughts, we assess certainly, I think personally we do at IDR, I think we do a good job of we don't take every case. We certainly don't file due process in every case. We only do those, which we've done probably, 5, 6, 7 in the last 3 or 4 years. We only file those when it gets to that point. We start at that low level, which I think the system's supposed to be about. We start at the case conference. We don't send an attorney, we send an advocate. If it gets to mediation, we move through it. If it gets to that point where there's a fundamental disagreement, okay, the due process is there for a reason. That's why it's here. Let's file. Oftentimes that is, as an example of in a past situation, it's a expulsion. It's an MDR where we are adamant that this behavior was related to the disability, and therefore they shouldn't be kicked off the rest of the year. And so the school thinks the reverse. There's a fundamental disagreement there. And a case conference isn't going to solve it. Mediation is not going to solve it. It's going to take a due process. So that system's there for a reason. But I don't think, and I'm almost positive that the vast majority of these are not bad actors. And I don't know what to do with the bad actors. So there's your non-answer, non-solution. I wish I had a better one, but that's what we're up against. We're up against these problems where there are bad actors in all parties, probably, and we can't blow up the system and infringe on everybody else who really need that system to fix the bad actors.
Are you just a question from your agency in and of itself, are you beyond capacity? You said you don't take ones based on the legitimacy of the case as you all see it, or I'm putting words in your mouth there with what you said.
We don't take every case.
Okay, you don't
we don't take every case.
Is that because you can't handle every case, or that you see that case is not one, in you all's opinion? Are you at capacity is what I'm asking. Are you turning people away who need help? There's my question.
I don't think that we are, I don't think we're at capacity.
Okay.
I don't think that we're turning away people that need our help. Some of the calls we get from a special education limited standpoint, we provide technical assistance, okay? They haven't even made a request to the school. Hey, they're new to special education. They need an evaluation. This is how you do it, That can be solved in a phone call. InSource is there, okay? And InSource is very capable and is there for a reason to sit at those case conferences and assist the parents in making some of those requests. We frequently make referrals to InSource on some of those things that we don't think is quite ready for us yet. InSource makes a lot of referrals to us that they've assisted at that level, and they're hitting a stumbling block, and we think it's something that maybe you need to handle. So a lot of those, a lot of the ones that we don't take, there are other resources out there, there are other avenues out there that doesn't take us yet. So that's largely the reason. I think I mentioned in the first meeting, we probably have a standing special education caseload of 35 to 40 cases at any given time in all aspects going throughout the year. Obviously that dips in the summer a little bit. But no, I don't think we're at capacity. I just think that we're limited funding. We need to, use that funding in the best way we can. And when there's other sources out there that can start it, whether it be just technical assistance for the parents to kind of go at them and self-advocate themselves, because if they can self-advocate, that's excellent, and they need to kind of learn that skill if they can. If it's InSource, they can try it there. And if InSource, can't get it accomplished, then maybe they can come back to us. So I think that's largely the reason why we deny cases. They come to us.
Thank you.
Mm-hmm.
I don't know if this is more of a Joel question. I kind of want to ask the same question of InSource as far as just volume, and because I kind of get back on what you mentioned earlier, there is also a training aspect to parents. I mean, this is a hard regulation to follow. It's hard to navigate. A lot of times when a parent's calling, asking questions of me, I mean, every once in a while they'll kind of throw out an apology because, and what they're doing is they can't enunciate well. They don't speak the language, So I'm curious also as to, what InSource has in just volume and flow and just overall management.
I would say we're very busy.
Yeah.
We are very busy, and we do refer to IDR at the point we feel like this is beyond what we can assist the family with. We are very proactive in helping families learn to advocate for themselves. We have Article 7 trainings online. We present them in person. We have a Facebook presence. We do a variety of different type of trainings along with one-on-one. We are one of the parent training centers that do come and sit at case conferences. And we do work with our staffs to say, help the family work through the system when possible. On the other hand, there is a civil right ability to basically say that the family has done what they feel they could do. But we are very busy. We receive a lot of calls from families. Many of our staff are part-time. And at that point, one of the things we do is with consent, we will call the directors and give a courtesy call. All of our staff do that. I would love to say to Angie that it's great she presents that information, because one very small comment that I could make is many times, as she stated, the families don't know who the special ed director is. They think they've been dealing with the special ed director. And I do believe if across the state, special ed directors could consider being particularly intentional about making sure that their information is provided. Many times families feel like they move to due process because they do think that they have been dealing with the special ed director. And then we get out our books, or we happen to know who they are, and we'll say, have you spoken to? And they're like, no, I don't know who that is. And they must know who our child is. Well, no, not necessarily. So we do provide that training. We receive also a lot of calls from schools to brainstorm, from directors. We try to partner in all of those type of areas, but coming together to look at that situation for that family or that student, because that's what we're all focused on, is actually the student is imperative, and our numbers have increased substantially as we've increased staff and as we've tried to make our areas even smaller to better serve families. Our numbers continue to go up to help families and coordinate.
And I will make a mention here. We're not at capacity, but we are busy. Okay.
Yeah, right.
And we have one attorney who does education exclusively, and we only have a handful of advocates who are in other areas as well. So we are certainly busy, but we are not at capacity.
Rewind the video.
And I will say that as my special education attorney supervisor, that I'm saying we're not at capacity. He very well could think he's at capacity.
Well, and my question was more about as we look at, because I've made a list that I'll share here in a minute of things to do. If one of our recommendations is that our people who are supporting need more whatever, and I know that's a federal funding issue, but yet that's what I was getting at, right? Do we need more of others? So I wasn't looking for, I'm not going to be out, tweeting that you all don't have enough work.
Just wanted to follow up on
or whatever, right? So, and if my video crew, if you all can just back up, take that other part out and fix that. So, yeah, thank you.
Dr. Ernst, to piggyback on that, I would say you might want to make a recommendation that the state fund Indiana disability rights. As far as I know, at least when I was there, they were the only protection and advocacy system in the country that didn't get any state funding. All the funding came from federal. Every state is required to have a P&A system. IDR is Indiana's, and I believe that you are completely federally funded from a variety of different federal programs.
That's correct.
Would you accept some state funds if they were available?
Oh, I am certain that we would.
Okay.
Now that, with the caveat that is above my pay grade, but we would be taking state funds.
Well, the charge of the legislature was for us to come forth with recommendations, right?
Write it down.
And we are not sunset. We are not sunset in such a way. I think I brought this up last time as to when this committee does have to. We can get into a funding year as well if we wanted to. So that always gives people angst when I say that.
I think and maybe it happens already, so I'm going to refer to Angela in that case, but this concept of ensuring all parents know the chain of command, not my term, not yours, but of who the directors are. And I'll go back to the director that served, my school corporation serves 6 others as well. I will use the analogy of a chicken with the head chopped off at certain times of the year. So I don't know if ICASE, that's a question I'm asking, does ICASE make that recommendation that all directors have their contact information, identification included in all the documentation that goes out through case conference?
We definitely support that. I presented on my research at the fall conference last year, and that was one of my recommendations. I even had a screenshot of my cover page. So in the way that we're able to implement practice in a way that, or affect change in the same way you did as an acting superintendent, you share your good practices and ideas with your colleagues, and then it's up to them to try to do that. But so we are promoting that through our professional development and as a strategy.
I go back to the instance that came to the superintendent's level at that point. Many parents did not, they were dealing with the school level. That was a counselor, that was a special ed coordinator at a building level. And they thought that was the go-to person.
Yeah.
Either from a lack of understanding or for whatever reason. And then when it reached a point where there was some discussion, some conflict, they thought they'd reached the top level instead of having that knowledge. And I honestly, that's a great suggestion. It's fairly cost effective, and you just say as directors and all the school corporations, this information has to go out as part of the parent package.
Yeah. My name and email and contact, it's actually even my personal cell phone number, are on the top of all of our procedural safeguards.
And if your members
Printed
come
on
back
there.
and complain about that recommendation, just point them to me. Because, but I think that would, again, is a simple, possible solution. It may help 3 or 4 or 5 parents say, oh, well, I now can go here.
Yeah, absolutely.
Instead of I'm going to pick up the phone and call someone, or I'm going to call an attorney, or,
And we strategically placed myself at the bottom because we want them to start with the teacher of record and the building principal and the local director or coordinator, but they know that I'm there as a person too. Now, and I've helped families through that, like, okay, let's work this out with the principal, the teacher of record, that kind of thing too.
And I don't know if that can be directed or mandated, but I just think it's a good practice that could eliminate some of those, not all of them, but some of the issues where parents, out of frustration, start down a path of negative interaction and hard feelings.
And I don't know if you're saying this and I'm misunderstanding what you're saying, because I think having all that information at a case conference committee is important and should absolutely be shared. But one thing, we run a very large trust, and so we don't approve every disbursement request that comes through. And so there's a lot of back and forth between our account managers and the beneficiary. And once we realize that that beneficiary may not get the outcome that they want, we reply to them and say, if you're unhappy with my decision, these are the steps. This is we have we have an honorary board that looks at those, and then it comes to me as the CEO if it gets to that level. But then once a teacher knows that family may not get the outcome that they're wanting and expecting, then remind them of, there are more people you can talk to and take this to if you're not satisfied with what you're getting with me. Because I don't think just giving it to a family once during a case conference committee is enough. They're overwhelmed, they're emotional, they're getting a lot of paperwork. They're not going to remember. They have to be reminded. And again, I don't think all of the burden needs to be on the family.
I would also add the caveat of making the websites easier. I have purposely gone to different websites across the state to try to find their special ed directors. When I have it in my book, it's very difficult, many times. Along with their handbooks where a parent might be able to read what the situation is. So that's another very simple thought that might help.
I think this has come up both meetings now. And I think it's on for next meeting is the information and communication strategies, the parents and students. So I think it's going to be a very beneficial discussion on some of those strategies, your cover letter and whatnot, and maybe if there's a way to require the schools to do it, I think it'll be very helpful next week or next meeting.
Dana, I'm gonna ask you this, or anyone. I always kind of direct, right? But I think I want to make sure I'm directing to you because I don't want you to think this is not a jab at the department. This is a question of me being creative, okay? Because I'm kind of known for being radical and creative. Do we need a place where? So I think parents sometimes it's weird to call the Department of Education, right? Having as a parent and having talked to parents, right? Is the department like pro for the school? Is the department pro for the whatever, right? would it make any sense, and please also know, this group doesn't know me well enough to know, I like to ask questions sometimes that I'm not sure I agree with the question that I'm posing, but I'm asking it to flesh out, right? So would it make sense to have somewhere different or somewhere where a person could call? We have all these agencies, or not agencies, but groups and wonderful resources, right? Is there a place that would be not more whatever, even perception, because perception's reality, so bias one way or the other, some place that could act as somebody calls in with a question, hey, you probably want to talk to, where you all are doing that anyway for each other, but would it make any sense to have that? Am I making any sense with my question? To where we had a new, and I can't believe that I would even be suggesting one more piece to the process, but I kind of am, because it would be small, but I'm thinking somewhere where even a school, if Pat Mate wants to call as a school, I could call for questions, or wherever, to get me to the right resource. Am I making sense with that?
Yeah.
Real quick though, are you saying something apart from category 9 of the ombudsman? Just for clarification.
I don't know what I'm saying.
Okay.
For sure, okay? So let me just be wild and crazy
Yeah,
on
but
that.
let me just answer that, if you go to the Department of Education's website, there's a directory, you can find all the employees.
Right,
Emails
right.
and phone numbers, as well as each division's, webpage. We get questions, telephone calls, emails every day, a bunch of them from both parents and schools. Now, is there a perception out there that we're, biased one way or the other? I'm sure some people have
Sure.
that thought, and it may depend on the answer that you get from me. If you're a parent calling in and I didn't tell you what you wanted to hear, you might think that I'm in favor of the school. But, the same thing. I talked to some of each this morning. And if you get me, and I'm not the one to answer your question, I will refer you to somebody else as well. So I had a call this morning from, a director saying that they had an issue about a kid with a seizure disorder and needing some medical information. So while I answered the question the best I could, then I also referred her to our school nurse. And I said, because she can give you some other ideas and different perspective on this. So, we try and be available and responsive to everybody, and it's generally our policy to respond within 24 hours or a business day if we do get voicemail messages or emails that we weren't there. So we do try and respond to everybody.
That was not me saying you weren't. That was me saying, is there a more less hostile way of
Yeah, and as Patrick pointed out, issue number 9 here is would there be a benefit to having
Right.
a special ed ombudsman to, so we'll be talking about that sometime, whenever that's up. Is that next week or is that
2 weeks, yeah.
in 2 weeks?
See, I keep jumping ahead, sorry. But that's good. Okay.
Yeah, it looks good. 2
thank
weeks,
you.
so in our next meeting, that's one of the topics there.
You're right. Dr. Taylor, did you have something?
I was going to use the word clearinghouse, but I to kind of put in my mind, but I'm not sure that's what you were saying. It's more of to try to find resolution at the lowest level of responsibility. Pardon me, excuse me. And I think that would not only prove to be much more efficient, but much more effective in getting services to the child sooner. So while sending multiple information to the parent, but even at that point, if we can get resolution before it gets to the director's level, but yet the director is knowledgeable, I think that's, whether that's what you intended to do, Dr. Ernst, or not, that's where I'm going with it, so.
No, yeah, you're just more eloquent than I am at that. Yeah, absolutely though. But that is the case, right? I think that is the goal here with that.
And I think that fits in with the type of advice or what we talk to parents about. If they call in and they're having a particular issue, we do say, well, have you talked with your child's teacher? Have you talked with the teacher of record? Have you talked with the principal? And director, we kind of go up the chain of command to try and resolve it at the lowest level. Did you ask to reconvene the case conference? These things you can do. And we're always talking about these less confrontational methods of resolving things before we ever get to talking about complaints, mediations, and hearings to try and resolve it earlier. And starting at the lowest level, you know, but if it's something we can work out with the teacher of service or the teacher of record, it might not need to go further up. But it depends on what the issue is. If we need to revise the IEP, then we're gonna have to go back to case conference or have a written agreement to make a change.
The caveat that it's great at lowest level unless the decision maker at that lowest level responsibility is irresponsible.
Yeah.
Then you have to continue to move on up. And that could be both sides of what we're talking about. So while we would all hope that, yeah, that teacher record would be able to address that issue with the parent and have a mutually agreed program, if one or the other proves to be irresponsible in their interaction, we have to be able to have that built-in practice. Again, I'll go back to the suggestion of having a clearinghouse. So as a superintendent, it normally doesn't get to my desk until someone thinks we're going to get sued. And when it comes to my desk at that point, then I'm working with my director, but I don't have any other resource. I may call a fellow superintendent and say, uh-oh, well, what do you point to me? If there was a website, a point of contact, before I had to call my own attorney, which the billable hours start again, I like attorneys, don't get me wrong. I think that's another part of the solution that we may be able to put forth as a recommendation, Dr. Ernest, that's not that expensive and may have great influence in getting our ultimate goal, which is to make sure services are provided without a lot of interference.
I will say also, we're in the process of we may have mentioned this in the last meeting, I forget, but we're in the process of updating our dispute resolution website, which, it's still a little bit in its infancy, but we have those things. I think it's probably gonna have something to the effect of question 1, have you talked to your school yet, or your special ed director? We may even have a link in there.
Yeah, we're going through informal
Yeah.
dispute resolution methods before you get to the formal and kind of going through all these things we're talking about. So while we can't require that they go through these, we are at least putting those first so that you see those as suggestions before you get to us talking about complaints or mediations or hearings.
Well, and I think I'd like to also say the fact that I think it's great that Indiana is the only state that's put someone from their parent training center embedded in the Department of Ed. So at the point when someone from DOE says, would you like to speak to someone else that can discuss some of these issues with you, then I'm there. And at that point, I'm going to be sending them someplace or to talk about something to someone. Because you're right, if they've gotten an answer that perhaps doesn't quite sound right, the thought is, what's your next step? Who can you talk to in that district that might be able to have a discussion with the third party there? So, I think InSource has been very appreciative that the department has allowed to have someone be there to try to help walk through some of those issues, because I think a lot of it has to do with communication.
Most of it has to be.
Yes.
Go ahead. I was going to switch gears a little bit, so if yours is on this one.
I'm trying to think how I can tactfully say this. Resources are great, and everybody needs resources. But I will just say, from personal calls that come into my office, parents want you to solve the problem. So for instance, if I say I can't tell a school board to do ABC, I can be that resource, I can give them strategies. But when I say I can't force the school board, the superintendent, the director, that's a frustration for any individual. So I'm trying to be very careful how I say it, because that's how education is in Indiana, and I'm certainly not advocating that we need another level overseeing, right? What a school board does, what a director does. So that I point that out just as resources are great, but just sometimes people want you to just come in with the hammer and say, this is how we're going to fix the problem.
Yeah, we get those things too, Lisa. I mean, I can't tell you how many times I've had someone say, well, then what good is the Department of Education if you can't make a school do X, Y, and Z? And at the same time, we also understand that, some of the calls we get, there's two sides to every story. Okay, and I've had several calls where a superintendent or principal would call me and say, well, now Dana, I just talked to this parent who said that you said X, Y, and Z. And sometimes I'll be like, that's not what I said at all. That's what the parent told me, and I told them the opposite. But then they turned around and went back to the school and said I agreed with them. Or maybe that was exactly what I said, but what the facts that the parent told me were entirely different than the facts that the school sees. So I guess piggybacking on what Lisa was saying, I don't think that we want to have some other level here that's going to be dictating any particular outcome, because again, you would have to be a fact finder and you'd have to fully hear both sides and stuff. So I think we want to be careful about additional layers at the state level to try and put the hammer down on the schools about what they
I
should
think
do.
we also have to be cautious and not try to compensate with some way for human nature. There are going to be some folks, no matter what this group comes up with, that will not be happy and will want to jump from A to Z, or want you to call and say, Lisa, I want you to, go and change the school board's decision, or the superintendent's. That's a minority, but they're the loud squeaky wheel.
Yeah.
So that's who resonates in our ear most of the time. So I don't want to personally get tired, because I like to fix those, because I can't tell you how many times I said, well, Dr. Taylor said, and when somebody calls me back, I said, no, we're not going to buy a brand new swimming pool because their child just learned to swim. We're going to, and so you have to, here's the rest of the story. I call it the Paul Harvey of education. Here's the rest of the story for what happens. They're out. That's going to happen. And I tried to learn long ago that I can't fix that, nor can anyone else. But I do think that that's a big issue we have. People call, and their level of frustration and anger escalates because they didn't get instantaneous satisfaction that they wanted. So, point well taken.
Angie, could you talk for a moment about, so recommendation of a tiered approach, different maybe than what we currently have? Some people think we already have it. Can you talk a little bit about kind of your thoughts on what that should look like?
Yeah, I didn't have a necessarily different way to do it, just that it would be required that we utilize those other forms. They're successful when they're utilized. I do have a thought, though. I wonder about a mediated resolution session. So when we get to the point of the resolution session after we've had a request, and I think there's a state that does this. I feel like I came across an article once, but I don't recall specifically. So this is something on my to-do list to follow up on as well. But if we had a mediator in the resolution session, that neutral party, somebody said it earlier, without financial interest, that could help the family and the school. Family, what is it you need and want for your child? What solutions are you seeking? School, what is it you're able to do? And if we can get that in that meeting and everybody could sign and walk away and start implementing that for the child, I think that'd be amazing. But right now, it's just the family and the school. And you said earlier, Dr. Ernest, and the family feels like I'm intimidated, afraid, or, and everybody has already consulted their attorneys and nobody wants to agree with anything without going back to their attorneys. So it puts everybody in this unwinnable situation. But if we had a neutral mediator in on that resolution session that could kind of help with that, I think that's worth investigating. I've been involved in several mediations. I love the process. They're really, really valuable process. Usually takes most of a day to get through one mediation, but in the end, we've resolved it and we've been able to solve the concerns. So that would be my one idea, is that we think about mediated resolution.
I would offer that is an option that's available. The parties can always agree to use mediation in lieu of that resolution session. So that's a process that's already there.
It's not, I'm thinking of combining them. Because mediation, both people have to agree. But what if you've already been through mediation, or you try to facilitate an IEP, and you're like, no, I'm not. But I'm talking about the actual resolution session.
Yeah, I understand that, but I don't, I'd be really interested in how other states do it, if they are mandating that the resolution session be mediated, because mediation,
It's usually voluntary.
it's voluntary, and both parties have to
Yeah.
agree, and I think that that's required under Indiana's alternative dispute resolution rules. I don't think that we could mandate that parties do mediation if they're not in agreement.
Yeah, and that's where I'm just wondering, could we assist in the resolution process? I'm not suggesting we change the mediation process. I agree that both parties need to be willing to engage in that, but I just wonder how that could affect the resolution session.
Yeah, but I did mean, under the hearing
It's allowable.
regulations, it does say that you can agree to use mediation in lieu of, you know, the resolution session. So, you know, it's an option that is there if the parties want to use it.
Anybody else? Okay, will you allow me to recap then? And please listen to this, because I want you to either add, I was gonna do a top 10 list, but now I got like 11 or 12 or so. I'm really not sure what I got at this point, right? So just allow me to work through what I think you all have talked about, right? And where I think we need to probably then concentrate, if we have some consensus on these things, then how do we move forward? Some of them are on the agenda, some of them are not. I've heard loud and clear, and it's number one, and I left it number one. So training for mediators, hearing officers, and we need to make sure that we've got that right. And maybe even expand that. How do we have more? I think I've heard that as well. And then I've heard joint training for parents and schools. What's that look like for that? And I like the idea of having parents and students together, or parents and families together, right? I think that brings some different dynamic for that. Reflection of family and schools after mediation. How do we get to something like that? So some kind of a reflection afterwards. School corporation reporting. How do we get the right boxes checked? How do we get the boxes we need? What's that look like from a systematic standpoint, right? Which then goes to what are the correct boxes. Entry-level resolution. What does that, and we could probably put, that's why I said I don't know what number we've got of this, right? Entry-level resolution, how do we find resolution at the lowest level? What's a mediated resolution session maybe look like? And those kinds of things. We already have it available. What could that look like? Available resources. How do we get a consistent, what are the available resources, whether that be a listing with pictures of who the people are within the corporation, what's that look like? Do we require some of that? What does that? Getting sources and resources where they're needed. I wrote down the clearinghouse piece. Is that, which is probably more about what I was looking at than anything, some kind of clearinghouse for both parents and school corporations with that. And then the last thing that I had on my list was then funding for IDR. I wrote that because I'd actually had people tell me that as I was working into this, right? So I think that those are the things that I heard today. What did I miss that you all heard or think needs to be? And again, some of those are on the agenda, but I wanted to run down that list because I think we also need to kind of discuss how do we begin to flesh some of those things out, right? What does this training piece look like? Because I'm not sure we have training specifically as an agenda item, and if I'm wrong, I apologize. But that would be what I heard today. I was trying to keep track as I was listening to that. Did I miss anything?
I don't know if 4 would also include parent reporting. I think for 3 and 4, you'd want to get the full picture for parents and schools.
Okay.
I think it's also important to make the data collection consistent. So we talked about Dana kind of breaking those those mediators selected and ALJ selected items, break them down a little bit so we can actually see some useful data. I think that, I don't know if that would fall in any of those, if that's separate, but I think looking at that would be helpful.
Yeah, you're saying what I think I was saying, get the boxes right.
Gotcha.
That
Yep.
we were gonna check, right?
Yes,
But
get the
you-
boxes
You
right.
said,
Exactly.
or I make things maybe too simple at times, right? Yes, absolutely though. What else?
I wonder if one of our items should be a collective mission and vision, a true north by which we can all continue to check ourselves as we work together as agencies that represent individuals with disabilities, so that we know this is what we're about and this is what we're committed to, and we continue our work for years to come in with that, like, this is what we're about.
Okay.
And when I mentioned resources and paper resources, I think are great, but again, I think I'd like us to look at resources available to the parties in the form of persons. You know, it may be in addition to InSource, in addition to IDR. What other entities, organizations, persons are available as a resource to the parties?
Okay. Anything else?
Shiny object, and I'll apologize if I'm off track, but I'm sitting here listening, and I like what we presented. I'm kind of curious from some of the members, does language seem to be an issue? We've seen that as an emerging problem. Some of our small suburban corporations are facing 19, 20, 21 different languages at home. So it used to be, well, we'll just get a Hispanic translator and that'll, well, you know, you can find much more from Mandarin to Botswana, whatever it is. Is that an issue? Does that come across, or is that just secondary and it's all been dealt with? I'm asking for my own information.
We've dealt with it. We had actually kind of a drawn out one. It didn't obviously go to due process or anything, it didn't need to, but we have a pretty large Burmese population in Indiana. And there were some cultural things related to that, but also some documents that weren't being provided in the native language. And so the parents didn't know what was going on. So there was, I mean, we've dealt with that. I don't know how to kind of, with a broad stroke, kind of fix that, but it's something that is certainly relevant that we've experienced.
I think it needs to be on our radar as an awareness factor we need to have.
So, thank you. Kind of affirmed, but I know going back to, say, a clearinghouse, kind of information place. I know from the school corporation's perspective, that would be a tremendous asset. If we did have the one exposure to a language that there was no, not even Google would translate for us. And I've seen that actually happen. It's a place, and I don't know if that's an issue we want to take on. That's kind of a secondary issue to everything else. And I appreciate the real life experiences you're having. But again, shiny object, I apologize.
Well, I don't know. When we say secondary, to your point, it becomes the issue if I don't know my resources, right? So I mean, your point's really well taken. It probably, there could be issues caused because of that, right?
It would do me no good to know who the director is if I can't read the document or understand the conversation. And yet the whole line of communication, I'm going to go back to that. And so, thank you, sorry.
Yeah, I certainly agree with that. The only reason, honestly, the only way that Burmese family found us is because there was a church assisting them. So, they probably wouldn't have even got to us, had there not been some other further assistance that noted that. It's a difficult problem though. I mean, I learned there's several dialects of Burmese as well, like even within that language itself, So I don't know how to fix that, but I think it's a pertinent question and something we should look at because if we're finding that kind of a resource is helpful to address many of these issues, we need to make sure that everybody can use the resources. I agree.
And again, I think it's a reality, so I'm not sure the problem as much as it's just a challenge, and if we can help minimize the response to overcome that challenge as part of our recommendation, that may again have some collateral influence on some of these questions.
When that becomes sharing resources, right? That somebody had, because to your point, Google Translate, the thing I've found, great tool, But if you don't edit what you get from Google you almost offend the people that you've translated the language to, right? Because it's not perfect when you get to that point. So, but to your point, if somebody else has, because I know Pat has a huge Burmese population. Well, if they've already got somebody translating something and then can pop that to wherever, to where you know, then it becomes shared resources at that point, right? Which I don't think we do enough of a lot of times either.
Thank you.
Great point.
One more thought, and it goes along with my idea of mission and vision, is how do we evaluate ourselves for years to come? Is there a process through maybe even existing avenues already, the state advisory board, or I think there's a special ed advisory board, something where we've got just some metrics to know, like, and we even monitor the data to say, are we reducing our number of negative incidents, increasing our awareness? Are we just keeping ourselves accountable?
Great. Anything else at all? So what I maybe would suggest is, because we've got a lot here to digest, if we could send out, and Tim, I can help decipher some of this. Could we send out to you this list that now we've kind of co-created, you all have added to? We may not be using exactly the same language, so we may need to get some things right where I'm calling check boxes, we need to call other things. Then could you all, if I could offer a homework assignment between now and the next meeting, maybe look at if there are areas in this specifically that you personally or your organization would like to help look at, hey, this is what we could do, or this is what this could look like. And then make this a discussion item at the next meeting of these items, however many it comes out to be now. I think 15 if I'm close here. But of those 15, and some of them are going to be easy things, right? Or hey, we don't want to, but maybe you give some thought with those you represent on what that might look like, and we can have a discussion about what some next steps to make that would, like, what would training look, what would better training look like? What would those things, am I making sense with this? What might a mission, vision, state, you're obviously passionate about that. What might that look like, right? And to be, does that make any sense at all? Does that sound like a good thing?
Very much so. I go back to just the comment about, I call it a debriefing after action report, but that's my background. So a matrix to say, okay, we're done. It went okay, it didn't go okay, but can we look at that? And I think that has great benefit. It could be done with minimal time and effort, 5-minute roundtable, but as an after action or after process, it might help guide us into the next step.
You're talking about that reflection piece?
Yes.
Yeah, okay, great,
We're talking
yeah.
about that, and maybe that's what I took it to be. We're done. In many cases, at the school level, the next family's waiting to come in and start their case conference. But if you took a 3 to 5 minute, and I may be off there, but that process is what I thought could be very beneficial.
See that Dr. Taylor already has number 3 taken care of.
I'm not sure, but I'll do my best.
Right.
Is that good?
I love it. Yeah.
Anybody, anything else then? I kind of felt like we were coming to a closure of that. Our next meeting is August the 22nd. Tim, are we in here? I can't remember where we, and everybody got their invites, I'm guessing, right? So it's on there, but I always like to say that, but I can't remember where it is, and I apologize. I should have looked.
I have conference room 1 and 2.
Okay. Sounds right. Okay. Perfect. Thank you. And then we look at category 3, 5, and 9, and then we'll also take a look at this list of however many it comes out to be, and we'll flesh that out further. And again, if you'll do a little homework on, hey, these are some areas that we particularly have some specialty in, or that we have passion about, or what have you, or even, hey, coming back and saying, let's take this off the list, whatever, right? And then maybe we can bring some consensus around that. Anything else for the good of the world? Anybody got anything else they want to bring up? I would entertain a motion to adjourn.
So moved.
Second.
Okay, it's been probably moved second to adjourn. All those in favor say aye.
Aye.
Opposed? We're adjourned.
Thank you.
Good work.